Welcome to All Things Financial with Jack Driscoll.
Welcome back, everyone, to another edition of All Things Financial. As you know, I do this show every week to put out to all of you viewers and listeners a lot of the different areas regarding anything to do with money, finances, estate planning, financial planning, taxes, insurance, all of the concerns we all have as individuals and business owners alike. So today, we're privileged to have a guest on the show with us for the next couple weeks, Matt Carl. I appreciate your coming on the show, Matt.
Well, thank you, Jack. I appreciate the opportunity to be here and to talk with your audience.
Thank you. Matt's going to tell us a little bit about some of the areas that he deals in and what he could share with us. So, Matt, if you could tell everyone just a little bit about yourself, where you've come from, what your practice is like, and then we can go on from there.
Well, Jack, I've been an attorney since 1982, and in those years, I've dealt with a lot of businesses and individuals, handled estates and trusts as part of a broad practice of clients. And in doing so, I ran across a lot of interesting people, including financial planners like yourself. And they always ask me, what is some of the basics about an estate plan and why do I need one? And I thought, well, maybe today would be a good opportunity to talk about that.
That's a good, interesting question because we've seen right now an extension I just saw this week of the high limits of this federal estate tax. We used to be so concerned in the 80s about beating this estate tax, and now you don't hear so much about it, and some people have gone so far as to say, maybe I don't need estate planning anymore. What's your take on that?
Well, I just ran across a case today where somebody back in the 80s put together a very complicated estate plan simply because they had $600,000 in assets. Mm-hmm. Now that plan is really cumbersome and we're trying to get them out of it. But nowadays, unless you're in the literal top 1% of the country, that type of complex estate planning is not really necessary unless you have children with special needs or, you have special situations involving individuals that you want to benefit from your estate, in which case we look at trusts and things of that nature. But the bottom line is if you don't have an estate plan, Jack, you're letting the government decide where your money goes. And secondly, you have probably some assets that may be very expensive in trying to transfer to the next generation. And part of a lawyer's job is to take a look not just at what you want to do with your property once you pass away, but also how is the most efficient way of doing that. And that's why we get involved. Typically the first thing an estate planner will do for you is ask you questions about your family, who they are, how old are they, do they have any special requirements, are they people that spend a lot of money, are they people that don't spend a lot of money, do they have any kind of addiction problems, things of that nature to help us understand what is it that you want to do with your money when you pass away. What happens if you don't have a will, which is the basic, document in any estate plan, is the government will say, okay, if you're survived by a spouse, a certain amount of money will go to that spouse, and then the balance of it will go to your children. And that is not necessarily what everybody wants to do, but it's what the government thinks most people want to do.
So you're saying without a basic estate plan, which includes without having a will at all, maybe they haven't gotten to that point in planning, and they're married, and the norm, but not always, might be that each person wants the married partner, the spouse, to inherit everything. That would not happen without a well-constructed will?
In some cases, no. In some cases, no. And
okay, that's a problem.
And then we have situations where people are living together, and maybe they have intentions to pass things to the person that's their companion, and when they pass away, if they have no will, they're totally out of the picture according to the intestacy laws. Okay. So there's issues that you should address in a will. Now, when we do wills, we take an inventory of your assets, and like we say, we talk about the individuals that you want to benefit from your estate and see what might be the best way to do it. Generally, what we do is we outline in the will what happens to the small items, the personal property, maybe some collections if you have some guns or coins, things of that nature. Some people collect cars. How do you want to get those out of your estate? Or do you just want them sold and then have the cash distributed? Then you have people that have particularly peculiar assets, which would be things like business interests. You may have developed a profitable business throughout your lifetime, but you don't have any children that are working in it, or you don't have someone underneath it to take it over. And so we take a look at those issues and try to help you with that. What if all of your assets are tied up in a very illiquid type situation? Even though federal estate tax may not apply to you, Pennsylvania inheritance tax will. And Pennsylvania inheritance tax, while not taxable to the spouse, is taxable when it passes on to your children at 4.5%. And so that 4.5%, if that's illiquid, then all of a sudden you have an estate where you have to sell your business just to get the money to the kids. Yeah. So those are the things that we kind of look at. We take a look at life insurance also, and see if in fact that's something that is needed to make your estate liquid enough to pay off your debts, pay off your taxes, and perhaps get some money to your children.
Okay. So we have a situation, every situation is different, but the beginning step is for people to evaluate their personal, family, and maybe business or whatever needs, and then also try to tie that together with documents to help accomplish what they would have written down on a napkin.
Right. Well, in fact, that's probably more likely than not that many wills, or what we call simple wills, in attorney parlance are called I love you wills, because essentially it says, if I pass away, I leave everything to you, my companion. Right. And if you pass away, you leave everything to me. And then after that, you have the decisions on how you want to leave things to your children or somebody else that you really prefer. But those simple wills, most attorneys can do those, and do those quite efficiently and quickly. And then, you can save them until you change your mind or your financial circumstances change.
Okay.
If you're working with a financial advisor and things have grown or shifted or things of that nature, then they'll make a recommendation to you. Maybe you ought to have your plan reviewed.
Which is interesting because right after 2000, I think I remember that being the time frame, attorneys were starting to call clients saying it's time to get back into review the estate plan, not so much for the will as I remember, but more for this HIPAA and powers of attorney and all those changes that had happened. And then lately, again, 2010 or 12 or 14 or somewhere in there, I understand that it changed again, where some powers of attorney that were done prior to that may not be. Can you fill us in a little bit of why things needed updated and why people need to review their estate plans even though they think they might be well situated?
Well, most of the changes that I can think of, there's been quite a few changes to the Trust Act and changes to what we call the Probate Estates and Fiduciary Code that wouldn't really affect too much in estate planning except in areas of powers of attorney.
Okay.
Powers of attorney are documents not necessarily for death planning, but for incapacity planning. So let's say you're in a situation where all of a sudden you have some type of either traumatic or medical condition where you can no longer make decisions concerning either yourself medically or financially. You're in a little bit of a bind because, financial institutions now are very particular about who they share information with and who's authorized to conduct business on your behalf.
Right.
So if in fact you do not have a power of attorney and you're incapacitated, well then people like me have to take you in the court and have you declared incapacitated and have guardians appointed. That's not a very cheap or efficient way of handling the problem. The most efficient way is during your lifetime, you can do what is called a power of attorney that says, I appoint someone as my agent to act on my behalf in the event of incapacity, and they can do the following things which are enumerated. Now, back in the early days in the 80s, when everybody had their own form of power of attorney and things of that nature, the banks would take a power of attorney and they would have their legal counsel review every single one of them to make sure that you weren't stepping beyond the bounds of that power of attorney.
Okay.
And so what eventually evolved over time was certain provisions were placed in the act that said, okay, if these powers are specifically enumerated or set forth, then financial institutions have to recognize those power of attorneys, and if they don't, they could be subject to some penalties.
Okay.
So if you haven't had your power of attorney looked at recently, you may want to make sure that somebody does to have those specific powers, because you could have a power of attorney and walk in and a bank or other financial institution will say, no, you know what, this is just not good enough.
Okay. You know, what I run into in my practice a lot are these situations with aging clients and the children coming to me, or sometimes the parents coming to me, and they're asking pretty much repetitive questions. Should I sign my house over to my kids? Should I add my kids' names onto my bank accounts? Should I have a power of attorney? Or, hey, mom or dad's slipping, the kids will call, they're slipping, we're noticing some things, what can we do about it? And sometimes it's too late because the parents have slipped enough in mental capacities that where it seems simple, you'd be able to, oh, hey, kids, you know, get authorized or have your parents do things. But some of the attorneys are telling us it's too late. Their signature is no longer valid, possibly, because they've, you know, so can you help with that situation on the aging and when parents and children and all should be having these discussions and, you know, in advance maybe,
Right.
type of preparations while everybody's good?
Well, you know, you should do yourself a favor, actually, and when you're thinking about it, do it yourself. Don't wait for your children to tell you, okay? The bottom line on testamentary capacity, and that's the ability to make a will, is that you have to know what your assets are. You have to know who what we call natural objects of your bounty are. In other words, you have to know who your kids are, things like that you have a spouse. And then you have to know what your plan is. So technically, testamentary capacity is not as high of a standard as you might think it is.
Okay.
But at the same time, when you do get into your elderly years, sometimes that comes in and goes.
Oh, yeah.
And you know, children at that stage of the game, you know, may be left with, as you say, no choice but to just rely upon whatever plan the parent may have had in place. Now, if in fact they had no power of attorney, you know, some people do put their children on their bank accounts as a matter of convenience. There's laws that govern that, but what unfortunately we're seeing now is, you know, when general broad powers of attorney are given to some kids, or when some children are giving, you know, access to bank accounts, they disappear. Or if they get put on deeds of their parents' homes and things like that, you know, to try to avoid what is called probate, which is what happens to transfer property after you have passed away. Well, then you have a situation that, you know, makes you extremely vulnerable to children that may need money and just have legal access to it without your permission.
That's some parents' greatest fear.
Yeah. So it's better to, you know, do yourself a favor, do your children a favor, do your estate plan while you know you're able to do it, and then you can protect yourself, you can protect your children in light of the fact that you're not giving them the potential to think, well, I have access to, mom's account, and mom doesn't need this much money, and I do. Yeah.
I'm laughing, but I've actually seen that. I'm seeing it now on cases. So we hear these stories, these nightmare stories of kids kicking their parents out of their home or taking assets. And we say, oh, don't worry about it. It won't happen. But if you need to go into a nursing home, it's best to have your kids on or someone that you trust. And then here the worst case scenario does happen. But on the other hand, the fear of putting the kids on, so not having powers of attorney in place, and then having the parents have dementia or whatever, no one to act on their best interest, might be a worse problem. So it's a toughie.
It is. I have taken several people through guardianships, and guardianships are court monitored. They're designed to protect the incapacitated person, and it requires a lot of reporting and supervision by the court. And it's very expensive, but the reason it's expensive is because the court deems itself there to protect incapacitated people, which is what they're there for. Yeah. Now, power of attorney works not the same way because there's not the reporting that's necessary. But if, in fact, someone abuses a power of attorney, they would be held accountable to the same court and have to file an account. And if, in fact, the funds of a person were improperly used, they would have to reimburse it. So there's a same level of protection generally on a power of attorney, and it's much more efficient. The other good thing about a power of attorney is oftentimes they're drafted very broadly with regard to what the attorney in fact can do as far as investments and things are concerned. Okay. When you're in a guardianship, the funds that you have the best. The only thing the court will let you do, absent court permission, is to put it into a interest-bearing account that's federally insured. Okay. And you know what those are returning right now.
Right. Yeah. Here's a question.
Sure.
The parents, for an example, have 3 children, all of which they trust, and both parents execute a general durable power of attorney for all 3 children, which would mean they could act in all the same capacities pretty much as the parents themselves, right? Similarly?
Yeah, it depends upon how it's drafted. Oftentimes you can draft it that they all have to act together, in other words, making the decision. But I've seen situations where, if one out of the 3 does not agree, well, then you're back in the court again getting a decision. Okay. I've seen them drafted where people say, okay, well, I have one daughter down in Florida where I live every 6 months, and one son up here in Pittsburgh where I live the other 6 months, and they both have my power of attorney, so when I'm up here, they can help me with paying my bills and, cashing my checks and things of that nature. And when I'm down there, the other daughter can do. And don't get me wrong, just because we know those stories, I'm in the business to hear people's bad newses, and the problem, and so it seems like it's more common than not, but frankly, there are a lot of good families out there where that type of abuse does not happen, and you don't hear those stories.
The norm in my practice has been everything has gone smoothly. Everyone that was trusted is trustworthy, and they do indeed take care of their parents or whoever they're given the power correctly. If in those isolated cases, a power of attorney was issued, let's say for this example, to the 3 children, and one of the children or the spouse's influence over that child becomes a rogue child and abuses that power of attorney, taking money out of the bank account, let's say, or something on the parents, what happens? Those powers of attorney don't expire. It's not like an expiration date that they need renewed. What happens? How do you revoke one of those things?
You just use the word, you revoke it. And generally what you would do is you would do a written revocation and file that written revocation in with the courts so that everybody in the world will know not to rely upon that power of attorney.
Okay.
And if you have financial institutions that you're a part of, I would give them a copy of that written revocation. Okay. So you can revoke a power of attorney, while you're alive. Once you pass away, your power of attorney disappears. That's when your will kicks in. Mm-hmm. Okay, so there's limited time on that. Now, one aspect of a power of attorney, too, not only deals with the financial side of it, but also the healthcare side of it. If you're in a situation where you cannot make decisions concerning your medical treatment, these things help physicians to know that, hey, I have appointed my spouse or I have appointed my child to make decisions for me. So that is also very helpful for, anytime you have a traumatic injury or anytime you're facing, illnesses and you just are not capable to decide, make a willing consent to the treatment that you're supposed to get.
Okay. What I find in my practice, everyone, we're running out of time, but it still revolves around setting up a team of professionals, surrounding yourself with a professional team. An attorney that's highly skilled, a financial advisor that's highly skilled, and a certified public accountant who's highly skilled, to surround your family with that professional team to help you make good and educated decisions, I think is the answer.
Yeah, that's absolutely correct. I didn't mention the accountant, but accountants are crucial, particularly when you have businesses involved in the estate.
Yeah. Matt, I appreciate your coming in. I very much do. What's your phone number or how people can contact you if they have any questions?
My phone number is 412-227-2500, and ask for Matt Carl. I'll be happy to take a call.
Very good, Matt. Thanks for coming on. We'll be back again next week. Matt's coming back on. We'll share some more good information with you. Thanks, all of you, for tuning in and listening. Again, we'll be back again next week.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through SagePoint Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with SagePoint Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.